So apart from the 13 accused, sorry, the 10 accused, the rest of the accused persons will have the chances given to them in the English language. So we will start with the changes being read in English language. The one who is reading the changes will skip the 10 accused whenever she appears, so that George can better read those changes to her in the real language. So Mr. Sarab, you can proceed.
Zakaria Obado, Dan Achola Okot, Scarlett Susan Okot, Jerry Zachary Okot, Evelyn Adiambo Zachary, Jared Peter Odoyo, Christine Akinyi Ochola, Joram Opala Otieno, Patroba Ochanda Otieno, Penina Auma Otago, Caroline Anyango Ochola, Bishop Limited, Touchdog Printers Limited, Kajuru Business Limited, Victoria's Investment Limited, Deltrack ICT Service Limited. You have been jointly charged with conspiracy to commit an offense, to commit an economic crime contrary to Section 47A, Subsection 3, as read in Section 48 of the Anti-Corruption and Economic Crimes Act No. 3 of 2003. And the particulars of the offense is between 29th December 2014 and 18th October 2016 within Migori County in the Republic of Kenya, jointly conspired to commit an offense, to commit an economic crime to which with unlawful appropriation of public funds in the sum of Kenya shillings 73,474,000 376 from Migori County Government. Zacharia Okoth Obado, true or not true?
Not true.
Accused number 2, Dan Achola Okoth.
Not
Number 3, Scarlett Susan Okoth. Number 4, Jerry Zachari Okoth. Number 5, Evelyn Adiambo. Number 6, Jared Peter Odoyo. Number 7, Christine Akini Ochola. Number 8, Joram Opala Otieno. Number 9, Patroba Ochanda Otieno. Number 10, we're skipping.
Number 11.
Number 11, Caroline Anyango Ochola. Number 12, Yusuf Limited. 13, Touchdog Printers Limited. 14, Kajuju Business.
Skip 14.
Oh, sorry. We skip number 14. Number 15, Victoria's Investment Limited. Number 16, Deltrack ICT Service Limited.
Kanena uma tambo. Intia. Yuindo. So yine mana volta ni business limited. Bura modo jinigo. Chikiti maber. Enne ne uriuru mondo mi kau pesa alo edito chik na mapa ngwen gabiro a de kiso me kare fra ngwen gaboro mama en chik mar ding kuoda gi sio di chik namba 8 lo pario de wachore ni kin tarik 29 dwe mar 10 higa mar 2014 o tarik 18 dwe mar 10 higa mar 2016 ka intie Migori County mayudore piny mar Kenya ka iriwori gi joma moko nowinjoru mondo mi ukaw pesa maromo siling milion 73,474 gi 376 koa kuom Migori County sirikal mar Migori County. En kamano koso kamano? Not true. Kajulu, wala mar Kajulu be mari. Orang kamano koso kamano? Kaluwore gi kambi. Guramo samra na dia koso kaya dia. On behalf of the company.
You have not this answered and confirmed.
Count number 2, Zacharia Obado. You have been charged with conflict of interest contrary to section 42 of subsection 3 as read in section 48 of the Anti-Corruption and Economic Crimes Act 2003. And the particulars of the offense is on 24th August 2016 at Migori County in the Republic of Kenya, being the governor of Migori County, knowingly held an indirect private interest in the contract between the Migori County government and Deltrack ICT service, pursuant to which interest a sum of Kenya shilling 10,874,938.55 was received by Dan Achola Okoth, your son. Is it true or not true?
Not true.
Not true. Count number 3. Zachary Okoth Obado. You have been charged with conflict of interest contrary to section 42.3 as stated in section 48 of the Anti-Corruption and Economic Crimes Act 2003. And the particulars is between 20th March 2015 and 26 January 2016 at Migori County in the Republic of Kenya, being the governor of Migori County, knowingly held an indirect private interest in the contract between the Migori County government, pursuant to which interest a sum of Kenya shilling 1,950,132 shillings 0.8 cents was received by your daughter Scarlett Susan Okoth from Jared Peter Odoyo Oluoch Kwaga on account. Let us you can sit down, please. On account of monies paid to companies by the Migori County government. True or not true?
Not true.
Count number 4. Zachary Obado, you have been charged with conflict of interest contrary to section 42.3, read section 48 of the Anti-Corruption and Economic Crimes Act 2003, and the particulars of the offense is from 29 October 2014 at Migori County in the Republic of Kenya, being the governor of Migori County, knowingly held an indirect private interest in the contract between the Migori County government, pursuant to which interest a sum of Kenya shilling 2,322,115 was received by your son, Jerry Zachary Okoth, from Jared Peter Odoyo Oluot Kwaga on account of monies paid to companies by the Migori County government. True or not true?
Not true.
Count number 5, you have been charged with conflict of interest contrary to section 42.3 as read with section 48 of the Anti-Corruption and Economic Crimes Act 2003. And the particulars is between 23rd December 2014 and 22nd September 2016 at Migori County, the Republic of Kenya, being the governor of Migori County, knowingly held indirect private interest in the contract between the Migori County government and Missoft Limited, pursuant to which interest a sum of Kenya shilling 5,901,486.25 was received by Scarlett Susan, your daughter. True or not true?
Not true.
Count number 6. Zacharia Obado, you have been charged with conflict of interest contrary to section 42.3 as read section 48 of the Anti-Corruption and Economic Crimes Act 2003, and the particulars is on 8 June 2016 at Migori County in the Republic of Kenya, being the governor of Migori County, held an indirect private interest in the contract between the Migori County government and Missoft Limited, pursuant to which interest a sum of Kenya shilling 1,806,700 was received by Dan Achola Okoth, your son. True or not true?
Not true.
Count number 7. Zacharia Obado, you have been charged with conflict of interest contrary to section 42.3 as read in section 48 of the Anti-Corruption and Economic Crimes Act 2003, and the particulars is on 26 September 2016 at Migori County in the Republic of Kenya, being the governor of Migori County, held an indirect private interest in the contract between Migori County government and Missoft Limited, pursuant to which interest a sum of Kenya shilling 2,178,981 was received by your son, Jerry Zachary Okoth. True or not true?
Not true.
Count number 8. Zachariah Obado, you have been charged with conflict of interest contrary to section 42.3 as read in section 48 of the Anti-Corruption and Economic Crimes Act 2003, and the particulars of offense is between 19 September 2016 and 21st September 2016 at Migori County, the Republic of Kenya, being the governor of Migori County, held an indirect private interest in the contract between Migori County government and Touchdog Printers Limited, pursuant to which interest a sum of shilling 1,400,380.80 was received by your son, Dan Achola Okoth. True or not true?
Not true.
Count number 9. Zachariah Obado, you have been charged with conflict of interest contrary to section 42.3 as read in section 48 of the Anti-Corruption and Economic Crimes Act 2003, and the particulars of the offense is on 18 October 2016 at Migori County, the Republic of Kenya, being the governor of Migori County, you held an indirect private interest in the contract between Migori County government and Touchdog Printers Limited, pursuant to which interest a sum of shilling 1,120,000 was received by your son, Jerry Zakari Okot. True or not true?
Not true.
Count number 10. Patroba Ochanda Otieno through Joyush Business. You have been charged with conflict of interest contrary to section 42, 3, spread in section 48 of the Anti-Corruption and Economic Crimes Act 2003. And the particulars is between 5th December 2014 and 7th November 2016 at Migori County in the Republic of Kenya, being employed by Migori County government as a pharmacist, held a direct private interest in the contract between Migori County government and Joyous Business, pursuant to which interest a sum of Kenya shilling 45,788,443 was paid by the said Joyous Business by the Migori County government, a business entity in which you are proprietor. True or not true?
Not true.
Not true.
Count number 11. Count number 11 is for Patroba Ochada Otieno, trading as fiscal engineering. The charge is conflict of interest contrary to section 42, subsection 3, as read in section 48 of the Anti-Corruption and Economic Crimes Act 2003. The particulars are that between 26 November 2014 and 7th November 2016, Migori County in the Republic of Kenya, being employed by the Migori County government as a pharmacist, knowingly held a direct private interest in the contract between the Migori County government and fiscal engineering, pursuant to which interest a sum of Kenya shillings 78,211,285.10 was paid to the state fiscal engineering by the Migori County government. True or not true, Patroba Ochada Otieno?
Not true.
Count number 4 is for Patroba Ochada Otieno, trading as Dolpha Software. The charge is conflict of interest contrary to section 42, subsection 3, as led in section 48 of the Anti-Corruption and Economic Crimes Act 2003. The particulars are between 19th November 2014 and 17th October 2016, in Migori County in the Republic of Kenya, being employed by the Migori County government as a pharmacist, held a direct private interest in the contract between Migori County government and Dolpha Software, pursuant to which interest a sum of Kenya shillings 39,409,643 paid to the said Dolpha Software by the Migori County government. True or not true, Patroba Ochada?
Not true.
Count number 13 is for Zachariah Okot Obado, Jared Peter Odoyo Oluoch Waga, Christine Akinyi Ochola, trading as Donkey Press, Joram Opala Otieno, trading as Makteba Contractors, and Delfrac ICT Services, Patroba Ochada Otieno, trading as Swiftcon Engineering, Dolpha Software, and Joyous Business, Caroline Anyango Ochola, Misoft Limited, Touchdog Printers Limited, and Victoria's Investment Limited. The charge is money laundering, contrary to section 3, subsection A1, as read in section 16 of the Proceeds of Crime and Anti-Money Laundering Act. the particulars are between the 21st day of January 2014 and the 9th day of February 2016 at Migori County in the Republic of Kenya, being the governor of Migori County, proprietors of business entities, directors of limited liability companies and limited liability companies respectively, paid by the Migori County government, entered into an arrangement for the transfer of Kenya shillings 256,703,688 to Jared Peter Odoyo Urut Kwaga on account of money paid to the same companies by the Migori County government, whose effect was to disguise the source of the same money, with joint and severally ought reasonably to have known the same money was part of proceeds of crime. True or not true, Zachariah Okod Obado,
Not true.
Jared Peter Odoyo Urut Kwaga,
Not true.
Christine Akini Ochora, Joram Opala Otieno,
Not true.
Patroba Ochanda Otieno,
Not true.
Penina Auma Otago,
Skip.
11, Caroline Anyango Ochora, Misoft Limited,
Not true.
Tag Job Peters Limited,
Not true.
Victoria's Investment
Kajulu.
Limited.
Janina Uma, Chumalo Toro, Reogi Mara. Dojugi Bura, Kanyakla di Yomo Seaka, Wuchi Mokongo, Nine Tipesa, Mane, Gore of Labs, Alora Number 8, the name of Faculty of I will only know work in a child in Koro, Central Mara Wachamato. Itari Correga Chial, Mara Chial, Gamara, Puerto Rico, Mara Reo, Gamara, Leo, Parga, County, Migori County, Mayore, Kenya. Koro, Kore, or any Unti, Sankin, Kavana, we go into the Mamoto, Director Mark Cabe, and in Tireka. Tipa, Monaco, Migori County, Manalo million, Niario Pravich, Gauchia. Mia biro kade isling mia ucia raboro bato mana chori jare kita royo luas wada kapesa hi ne kale kende man tire man tire ni ko koro mai ne chalo ni mundo yo uma pesa ki no ai magine ki pesa mayor ki ne okle en kamano to sok kamano no koro bom kambi en kamano to sok kamano tuli dua kodere yo kamano to sok kamano. Not true. Count 14. Zachary Obado. Mudo munya mbetu. Wacha kumachi. Dan Achola Okot. Joram Opala Otieno. Delta ICT Services Limited. The charges of money laundering, contract section 3F1, as read in section 16 of the Proceeds of Crime and Anti-Money Laundering Act. Particulars of the offense are that on the 24th of August 2016 at Migori County, in the Republic of Kenya, being the governor of Migori County, signed the Migori County governor and director of Delta ICT Services Limited and a limited liability company respectively, entered into arrangement for the transfer of Kenya shillings 10,874,938.55 towards purchase of a motor vehicle registration number KCK 722B chassis number JTM HV05 J504200 and KCK 997W chassis number JTM HV05 J404173096 Mike Toyota Land Cruiser on account of monies paid to Electric ICT Services Limited by the Migori County government, whose effect was to disguise the source of the said money jointly and severally, or reasonably to have known that the said money was part of proceeds of crime. Zachary Obado, true or not true?
Not true.
Dan Ochola,
Not.
Joram Opala Otieno, Deltrack ICT Services Limited.
Not.
We are moving to count 15. Zachary Obado, Dan Ochola, Joram Opala Otieno, College of Printers Limited. The charge is that of money laundering under section 3A1 as read in section 16 of the Proceeds of Crime and Anti-Money Laundering Act. Particulars of the offense are that between 12 September 2016 and 21st September 2016 at Migori County, in the Republic of Kenya, being the governor of Migori County, son to Migori County governor and director of Touchdog Printers Limited, a limited liability company, entered into an arrangement for the transfer of Kenya shillings 1,400,380 towards the shipment of motor vehicle edition number KCK 722B, basis number JTMH B05 J544 200-550 and KCK 99W, basis number JTMH V05J404-173-096, make Toyota Land Cruisers on account of monies paid to the said Touchdog Printers Limited by the Migori County government, whose effect was to disguise the source of the said money. Jointly and severally or to recently have known that the said money was part of proceeds of crime. Zachary Okot, true or not true?
Not true.
Dan Achola Okot,
Not.
Joram Opala Otieno,
Not true.
Touchdog Limited, Printers Limited, Touchdog, count 16. The charges of money laundering, under section 3A1, as read with section 16 of the Proceeds of Crime and Anti-Money Laundering Act. Zachary Obado, Scarlett Susan Okot, Scarlett, Jared Peter, Olua Chibwaga, Christina Kinya Chola, Miss of Limited. Particulars of the offense are that on the 23rd December 2014 at Migori County, in the Republic of Kenya, being the governor of Migori County, daughter to the Migori County governor, and the directors of Mesoft Limited, a limited liability company, respectively, entered into an arrangement for the transfer of Kenya shillings 1,951,846.20 for payment of school fee to Abadan University on account of monies paid to the same company by the Migori County government, whose effect was to disguise the source of the same money, jointly and severally out to recently have known that the said money was part of proceeds of crime. Zachary Okot, true or not?
Not true, my lord.
Scarlett, Jared Peter Odoyo, Christine Akinyo, Miss of Limited, count 17. Zachary Obado, Scarlett Susan, Jared Peter Odoyo, Christine Akinyo Chola, and myself Limited. The charges of money laundering for section 3A1, starting with section 16 of the Proceeds of Crime and Anti-Money Laundering Act. Particulars of the offense are that between 23rd December 2014 and 22nd September 2016 at Migori County in the Republic of Kenya, being the governor of Migori County, daughter to the Migori County governor, director of Myself Limited and a limited liability company, respectively, entered into arrangement to transfer Kenya shillings 3,992,640.25 for the maintenance and upkeep of Scarlet Susan Accord on account of money paid to the said company by the Migori County government, whose effect was to disguise the source of the said money. We jointly and severally for this of the people have known the said money was part of proceeds of crime. Zachary Okoth.
Not true, my lord.
Scarlet Susan. Jared Peter Doyle. Christine Akinyo. Christine? No. Myself Limited. No. 18. Zachary Obado. Scarlet Susan. Jared Peter Doyle. The charges of money laundering, contract section 3A1, as read with section 16 of the Proceeds of Crime and Anti-Money Laundering Act. Particulars of the offense are that between 20th March 2015 and 26th January 2016 at Migori County in the Republic of Kenya, being the governor of Migori County, daughter of the Migori County governor, and director of Microsoft Limited, respectively, entered into an arrangement for the transfer of Kenya shillings 1,950,132.80 for the maintenance and upkeep of Scarlet Susan Accord on account of monies paid by the Missouri County government to companies associated with Jared Peter Doyle Watchwater, whose effect was to disguise the source of the said money. Jointly and severally, or also make people have known, the said money was part of proceeds of crime. Zachary?
Not true, my lord.
Scarlet Susan? Jared Peter Doyle Watchwater?
Have we responded?
Yes, we all know.
Grant on 6. I want to have first official.
Speak up, eh? Scarlet Okoth? Jared Peter Doyle Watchwater? This one.
Count number 19. The charges for Zachariah Okoth Obado, Dan Achola Okoth, Jared Peter Odoyo Ulukwaga, Christine Akinyi Ochola. The charge is money laundering contrary to section 3, subsection A1, as read in section 16 of the Proceeds of Crime and Anti-Money Laundering Act. The particulars are between the 8th day of June 2016 and 10th day of June 2016 at Migori County in the Republic of Kenya, being the governor of Migori County, son to the Migori County governor, director of Microsoft Limited and a limited liability company, respectively, entered into an arrangement for the transfer of Kenya shillings 1,806,700 to Curtin University for payment of school fees on account of Dan Achola Okoth, being portion of funds paid to the said company by the Migori County government, whose effect was to disguise the source of the said money, which he jointly and severally ought to reasonably have known the said money was part of proceeds of crime. True or not true, Zachariah Okoth Obado?
Not true, my lord.
Dan Achola Okoth,
Not true.
Jared Peter Odoyo Oluochkwaga, Christine Akinyi Ochola, Microsoft Limited. Count number 20. The charge is for Zachariah Okoth Obado, Jerry Zachary Okoth, Jared Peter Odoyo Oluochkwaga, Christine Akinyi Ochola, and Microsoft Limited. The charge is money laundering, contrary to section 3A, subsection 1, as read in section 16 of the Proceeds of Crime and Anti-Money Laundering Act. The particulars of the charge are that on the 26th day of September 2016, at Migori County, the Republic of Kenya, being the governor of Migori County, son to the Migori County Governor, directors of Resource Limited and Unlimited Liability Company, respectively, entered into an arrangement for the transfer of Kenya shillings 2,178,981 for payment of school fees for Sheffield University on account of Jan Achola Ukor being portion of funds paid to the same company by the Migori County government, whose effect was to disguise the source of the same money, which we jointly and severally ought to reasonably have known the same money was part of proceeds of crime. True or not true, Zachariah Ukor Obado?
Not true.
Gary Zachary Ukor?
Not true.
Jared Peter Odoyo Oluoch Waga?
Not true.
Christine Akinyi Otora? Yusuf Limited? Count number 21. The charge is for Zachariah Ukor Obado, Jerry Zachary Ukor, Joram Opala Otieno, and Touch Dog Printers Limited. The charge is money laundering contrary to Section 3A, subsection 1, as read in Section 16 of the Proceeds of Crime and Anti-Money Laundering Act. The particulars are between the 17th day of October 2016 and 19th October 2016 at Migori County, the Republic of Kenya, being the governor of Migori County, son to the Migori County governor, director of Touch Dog Printers Limited and Unlimited Liability Company, respectively entered into an arrangement for the transfer of Kenya shillings 1,120,000 for payment of school fees to Sheffield University on account of Dan Atola Ukor being portion of funds paid to the same company by the Migori County government, whose effect was to disguise the source of the same money, which we jointly and severally ought to reasonably have known the same money was proceeds of a crime. True or not true, Zachariah Ukor Obado?
Not true.
Jerry Zachary Ukor?
Not true.
Joram Opala Otieno?
Not true.
Touch Dog Printers Limited?
Not true.
Count number 22. The charge is for Zachariah Ukor Obado, Jerry Zachary Ukor, and Jared Peter Odoyo Oluoch Waga. The charge is money laundering contrary to Section 3A, subsection 1, as read in Section 16 of the Proceeds of Crime and Anti-Money Laundering Act. The particulars are that on the 29th day of October 2014, at Migori County, the Republic of Kenya, being the governor of Migori County, son to the Migori County governor and a businessman respectively, entered into an arrangement for the transfer of Kenya shillings 2,332,115 shillings for the payment of school fees to Sheffield University on account of Jerry Zachary Ukor being portion of funds paid to Jared Peter Odoyo Oluoch Waga by various companies which are attached. These are Atina Services, Yankee Press, Delta ICT Services, Dolpha Software, Joy Business, Kajulu Business Limited, Makteba Contractors, Resource Limited, Vesulus Unit Supplies, Select Track Consultants, Silicon Engineering, Touch Dog Printers, and Victoria's Investment. Paid by the Migori County government, whose effect was to disgust the source of the said money, which we jointly and severally ought to reasonably have known the said money was part of proceeds of crime. True or not true, Zachariah Ukor Obado?
Not true.
Jerry Zachary Ukor?
Not true.
Jared Peter Odoyo Oluoch Waga.
Not true.
Count number 23. The charge is for Zachariah Obado, Evelyn Adhiambo Zachary, Jared Peter Odoyo Oluochikwaga, and Misok Limited. The charge is money laundering contrary to Section 3A, subsection 1, as read in Section 16 of the Proceeds of Crime and Anti-Money Laundering Act. The particulars of the offense are between August 2015 and 30th day of September 2015 within Migori County in the Republic of Kenya, being the Governor, Migori County Government, the Governor's daughter, Director of Misos Limited and a limited liability company respectively, entered into an arrangement for the purchase of Horatio Ridge House number C1, situate on land registration 21080 to 63 IR 197812, formerly land registration number 21080 to 38, title number land registration 74363, at a cost of Kenya shillings 34 million. $34,525,000 from Kenya Power Pension Fund on account of monies paid to the state business entities by the Migori County government, whose effect was to disguise the source of the state money, which jointly and severally or reasonably have known the state money was part of the money. True or not true? Zachariah Obado.
Not true, my lord.
Evelyn Adhiambo Zachary. Jared Peter Odoyo Oluochikwaga. And Misok Limited. Count number 24. Count number 24 is for Patroba Ochada Otieno, trading as Dolpha Software. The charge is unlawful acquisition of public property contrary to Section 45, subsection 1A, as read in Section 48 of the Anti-Corruption and Economic Rights Act number 3 of 2003. The particulars are between 19th day of November 2014 and the 17th day of October 2016 at Migori County in the Republic of Kenya, being a pharmacist employed by the Migori County government and trading as Dolpha Software and lawfully acquired public property, Kenya shillings 39,409,643 shillings from Migori County government. True or not true?
Not true.
Count number 25. The charge is for Patroba Ochada Otieno, trading as fiscal engineering. The charge is unlawful acquisition of public property contrary to Section 45, subsection 1A, as read in Section 48 of the Anti-Corruption and Economic Rights Act number 3 of 2003. The particulars are between the 26th day of November 2015 and 7th day of November 2016 at Migori County in the Republic of Kenya, being a pharmacist employed by the Migori County government and trading as fiscal engineering and lawfully acquired public property to which Kenya shillings 78,211,225 shillings and 10 cents from Migori County government. True or not true?
Not true, my lord.
Count number 26. The charge is for Patroba Ochada Otieno, trading as joint business. The charge is unlawful acquisition of public property contrary to Section 48, subsection 1A, as read in Section 48 of the Anti-Corruption and Economic Rights Act number 3 of 2006. The particulars are between the 5th day of December 2014 and 7th day of November 2016 at Migori County in the Republic of Kenya, being a pharmacist employed by the Migori County government and trading as Joyish business and lawfully acquired public property to which Kenya shillings 45,788,443 shillings from Migori County government. True or not true?
Not true.
Count number 27 is for Zachariah Obado, Dan Atola Okot, Scarlett Susan Okot, and Jerry Zachary Okot. The charge is unlawful acquisition of public property contrary to Section 45, Subsection 1A, as read in Section 48 of the Anti-Corruption and Economic Crimes Act number 3 of 2003. The particulars are between the 29th day of October 2014 and 18th day of October 2016 at Migori County in the Republic of Kenya, being the governor of Migori County government and the governor's children, and lawfully acquired public property to which Kenya shillings 38,949,376 shillings and 89 cents from Migori County government through companies and persons trading with the same Migori County government as per the attached list. True or not true, Zachariah Okot Obado?
Not true.
Dan Atola Okot? Scarlett Susan Okot? Jerry Zachary Okot? Count number 88. The charge is for Zachariah Okot Obado, Evelyn Odhiambo Zachary, Evelyn Adhiambo Zachary, Jared Peter Odoyo Oluoch Kwaga. The charge is unlawful acquisition of public property contrary to Section 48 of Section 1A, as read in Section 48 of the Anti-Corruption and Economic Crimes Act number 3 of 2003. The particulars are that between the 19th day of September 2014 and 4th March 2015 at Migori County in the Republic of Kenya, being the governor of Migori County government, the governor's daughter and a businessman respectively, and lawfully acquired public property to which Kenya shillings 34,525,000 from Migori County government through companies and persons trading with the same Migori County government, which money was used to purchase Floresho Ridge House number C1, situate on land registration number 21080463, inland registration number 197812, formerly land registration number 21080438, and title number IR 74363. True or not true, Zachariah Okot Obado?
Not true, my lord.
Evelyn Adhiambo Zachary? Jared Peter Odoyo Oluoch Kwaga?
Not So we have completed validation of applications. I will invite anyone who has any interest to make the report to do so. There is none. We leave it to the court.
Well, Your Honor, I wish to move an application under Article 49, 1H of the Constitution of Kenya for the release of all the accused persons on bond or bail. Your Honor, I will myself specifically address the circumstances of my client, the first accused, and my colleagues will deal with the circumstances of their own clients. The first accused, Your Honor, is a 58 years gentleman.
How old?
58 years. And this year has become extremely significant in the COVID times that we are living in. It is in his firstly personal interest that everything is done so that he is not unnecessarily exposed to the possibility of contracting a disease which, according to WHO guidelines, a 58-year-old is extremely susceptible. The second issue I wish to highlight, Your Honor, is under Article 49, Subarticle 1H, the liberty of an accused person is guaranteed notwithstanding that he is facing criminal accusations. And the guarantee in that article makes it a right of an accused person to be admitted to bail. The golden rule is each and every accused person must access bail or bond on reasonable terms. And the only time an accused person may not be released is if the prosecution satisfies the court that there are compelling reasons not to release an accused person. Your Honor, the first accused is prepared, ready and willing to avail himself for trial and to attend all court sessions that the court may direct. And the most significant and the primary consideration on whether or not to admit an accused to bail is whether or not he will turn up for trial. Your Honor, the investigating officer has placed before the court an affidavit containing 19 paragraphs sworn on the 21st of August 2020. In all those paragraphs, there has been no averment, no evidence produced before you that the first accused will not turn up for trial. And so, Your Honor, we are asking you to uphold the values of Article 49, 1H, and admit the first accused to bail. This application is opposed by the prosecution, and through an affidavit sworn by Robert Rono, the prosecution gives 6 reasons which they consider to be compelling enough for you to deny the first accused, and indeed all the other accused persons bail. These 6 reasons, Your Honor, I will give the 6 reasons to you, and then I will address each one of them. The first one, they allege he will interfere with witnesses. That is the first reason. The second reason they advance is there was arson case reported in Migori County. The third reason, they fear the accused will abscond. The fourth reason they put forward is that there is an existing criminal case against the first accused. The fifth reason they give is these are serious economic crimes. And the sixth reason, and the final one, is there are ongoing investigations, and the first accused is likely to be charged with other offenses. And so, Your Honor, permit me to respond to all these 6 reasons and to demonstrate to you that none of them is compelling. None of them. The first one, interference with witnesses. Your Honor, this you will get in paragraph 12 of the affidavit. And it is expressed as a fear. They say they fear there could be interference with witnesses, and there is therefore a possibility that witnesses would be interfered with. Your Honor, without concrete evidence being presented before you, you cannot act on the fears of an investigator. There is no objective criteria on which these fears are founded. There is gut feeling. These are subjective thinking. A court must be moved on basis of objective reason. Your Honor, the law provides for witness protection scheme. Parliament, in its wisdom, and cognizant that some accused persons may interfere with witnesses, put a law, set aside funds, so that when there is genuine fear, witnesses are placed under witness protection scheme. And so fear that there will be interference cannot take away a basic and fundamental right to liberty. And I ask you to find that this is not a compelling reason not to admit the first accused to bail. Your Honor, let me now address you on the question of arson, which is the second ground put forward by the prosecution. From the affidavit, Your Honor, this arson occurred on the 24th September 2017, where an office in Migori County was burned down, and criminal investigations were commenced. On conclusion of those investigations, the investigating officer wrote covering a report and stated its recommendations. And I kindly ask Your Honor, if that affidavit is before you, to turn to page RR3. At page RR3 of that affidavit. Your Honor, let me the one dealing with the recommendations. RR3.
Mine does not have RR3.
Well, physically it will be the to be the 5th page. RR3. You have it? You guys have it?
The findings.
RR3.
Unfortunately, my document is not labeled.
Sorry, it's not?
It doesn't have the markings.
Maybe the prosecution should avail Your Honor with another set, because this is what they have given us as we are seated here.
Usually what he has. What else is different?
Your documents are the same as mine?
Yes, yes, like yours.
Yes.
They are not properly arranged.
Probably the prosecution will supply Your Honor with another copy.
You can proceed.
Yes, but Your Honor, on that page RR3, under the heading recommendations, I just want to read 2 paragraphs. The first one there says, after considering the circumstances under which the said procurement office and store were banned, there is no evidence pointing a finger at any specific person for that fire. Then the investigating officer goes on to say, at the tail end of his recommendations, in the meantime, after careful analysis of the evidence at hand, I am not able to specifically point an accusing finger on anybody and recommend the file to be closed unless otherwise advanced. The investigating officer is one PC Rotich, and that is the state of affairs. This investigating officer works under the investigator of this case. That is the DC, that is the ESCC, or the police, I am not sure. So they came to the conclusion that they have no evidence. Why would it be brought here in this case as a compelling reason to deny bail? I invite Your Honor to decline that this is not a compelling reason. And now, Your Honor, I move to the third ground. The third ground is that the first accused will abscond. In fact, all of them will abscond trial. This is a preposterous suggestion. The prosecution knows pretty well that the first accused was admitted to bail in another case in 2018. He has been living in this country on bail from 2018, 2019, and we are now 2020. The case in which he was admitted to bail, the ultimate punishment could very well be death, but he hasn't run away. When the DPP circulated information globally that he is required, he drove himself to the offices of EACC at Kisii. The Tanzanian border was actually closer. He could have drove towards that direction. He drove to Kisii because he's a man who believes in the rule of law and fair administration of justice. So having put his faith in our criminal justice system, how can the prosecutors turn around to say he can abscond? He has demonstrated he cannot abscond. And I ask you not to hold this ground as compelling to deny bail. The fourth reason, Your Honor, is that there is an existing charge. It is true, Your Honor, that the first accused faces a murder charge in criminal case number 46 of 2018, in which I actually appear for him. But does the existence of another criminal case become a compelling reason to deny bail? Our answer is an affirmative no. And that no is derived from the Constitution itself. Article 50, sub-article 2A, presumes the first accused innocent until proved otherwise. And so the existence of that case, the murder case, is simply a matter of detail. It isn't a ground on which the court can deny the accused bail. I therefore ask Your Honor not to consider this as a compelling reason not to admit the accused to bail. The fifth reason put forward is these are serious economic crimes. And you will find that in paragraph 14 of Mr. Rono's affidavit. Your Honor, it is plainly admitted. It is plainly admitted that whatever Parliament has passed a law to create a crime, that is a serious conduct. It is a conduct that the society gets outraged when those activities take place. And there is no debate. Economic crimes are serious crimes. But the Constitution did not exempt serious crimes for admission of bail. For those who practiced law before the 2010 Constitution will recall the repealed constitution put in 4 offenses which they considered serious enough to make any accused person not be eligible to apply for bail. The 2010 constitution treats all offenses the same, and not a single offense has been made non-bailable. This remains a bailable offense. The fact that it is alleged it is serious, and indeed it is admitted all crime is serious, that's no reason to deny bail. Of course, again, Your Honor, the presumption of innocence comes to play once again. The whole idea of admitting an accused person to bail is because he is presumed innocent. So, serious crime or not, he is entitled to be admitted to bail. And then finally, the final ground. They say there are ongoing investigations, and indeed the first accused is likely to be charged with other offenses. Your Honor, look at that statement coming from the prosecutors and the investigators. They are telling the court on its face, we are prepared to do prosecutions in installments. That is the hallmark of abuse of the criminal justice system. If you had a case against Obado, bring it now. You can't keep on bringing it in installments. The Constitution itself, in Article 157(11), directs the DPP to avoid abuse of the legal process. Any prosecutor telling you he is going to prosecute in installments, that is a fellow who is abusing the legal process. Your Honor, there is a case, because we've just been served this as we were here. There is a case reported, English case, Conley versus DPP, and I would check the case and send to my learned friends. And it deals with prosecution in installments, res judicata, and estoppel, and their application in the criminal justice system. And they make clear, the House of Law makes it absolutely clear, prosecuting people in installments is abuse of legal process. Bring all those cases, we deal with them now. Not to keep on threatening citizenry, oh, we have something else in the bag. Bring everything you have on the table. Your Honor, I heard you. To find that none of these reasons are compelling within the meaning of the Constitution for you to deny the first accused bail. Your Honor, the prosecution did serve us with a list of authorities with fairly many cases, but we all know the principles on which courts admit accused persons to bail are well settled. And among the cases they have placed before you, I draw your attention to, in their list of authorities, number 17 and number 19. These are decisions from the Court of Appeal. Number 17 relates to Ren Kolel versus Republic. This is the governor of Samburu. And number 19 relates to Ferdinand Waititu, the then governor for Kiambu. Of those two decisions, delivered on the same day by the Court of Appeal, the Court of Appeal held that under Article 49(1)H or what the court is entitled to do is, absent compelling reasons, to admit an accused.
49(1)(8).
Sorry,
Under Article
49(1)(8) is to admit an accused person to bail in the absence of compelling reasons. But what the decisions emphasize, Your Honor, is that the court is given latitude by the Constitution in putting down reasonable conditions, so that it is up to this court, up to Your Honor, to put down reasonable conditions. In fact, many of the times, the reasonable conditions are crafted to meet all the fears of the prosecution. And those two cases really dealt with that. What is your fear if this person is released on bail? And then the court is able to craft an order that meets the justice of the case. Your Honor, I invite you to admit the first accused person to bail. In fact, Your Honor, in the event, because there are so many counsel who will need to present their clients' cases, and you will have to make a decision, I invite Your Honor, if it becomes necessary for you to take time to consider your decision, I invite you to take judicial notice under Section 60 of the Evidence Act of the COVID pandemic, which is a global problem. And even as you consider your ruling, to admit the accused person on their personal recognizance or personal bond on bail pending delivery of your reasoned ruling. And that will be safeguarding public interest. It is in the interest of all of us that this disease does not spread to everyone. My client doesn't know his status. Why should he spend 1 extra hour awaiting either a ruling or a decision of this court? New circumstances require us to adopt new ways of doing things. And I invite Your Honor to kindly consider whether it is not in the public interest, given the situation we are in, that you, in the event that you will need time to consider considered ruling, to ask the accused person to sign personal recognizance to appear when you deliver your ruling. Thank you very much, Your Honor. I have nothing else to add.
Any other counsel who have anything to add? The submission by Mr. Wilson. Mr. Wino, you are appearing for the second accused person. Let me say now, submission by the first. Mr. Wino, yes. For accused number? 2. The second accused. So I hope you are adding to what counsel has submitted, because you submitted quite extensively. So I hope you are not going to repeat yourself so much, so that you save on that. Well done. Proceed. We have to shape ourselves with the submission of senior counsel, and we make an application today. Second, accused person, as envisaged under Article 49, 1H of the Constitution.